Hi, I'm Mark Freedman, a partner in the Family Department at Osbornes. I'm going to talk to you very briefly about the international movement of children and specifically what you can do and when you can take a child abroad. International travel has become a dominant feature of modern day life. Many of us have family, friends and businesses in another country. It is not surprising, therefore, that sorting out the international movement of children after a relationship has broken down has become a thorny issue for the English courts. So what are the rules and regulations that determine this difficult issue? The starting point is parental responsibility. Parental responsibility, or PR as we call it, are the basic rights that a parent has in respect of a child. All mothers have parental responsibility. All fathers who appear on a birth certificate have had parental responsibility since 2003. All married parents share parental responsibility. If you have parental responsibility, you require the permission of everyone else with parental responsibility before you can leave the country with a child. If you remove a child from England and Wales without permission from the other parent with PR, you could be prosecuted for child abduction. If the parent will not give permission, then the courts are normally asked to determine whether a child should be moved abroad or not. At this point, lawyers normally distinguish between trips abroad for a short period, like holidays, and trips abroad permanently to go live in another country. If you want to take a child abroad on holiday temporarily, then the courts will normally let you go without too much discussion. You have to show that you will be coming back from that holiday and that the child will be well cared for during the holiday. So normally the courts will give permission. If you wish to go abroad for a longer period permanently, then you would normally have to show the court that that move abroad is in the best interest of that child. Slightly differently, if you want to take a child to live abroad, then you have to show the court and demonstrate that it would be in the child's best interest to make that trip. The sorts of issues that a judge will be interested in when determining what is in the child's best interest are usually the education that you envisage the child having in the new country, the contact that child will have with the parent that's left behind. Another important issue is what the child themselves would think about a move abroad, depending of course on the age of the child. And finally, the effect on you as the parent that wants to move abroad of being refused that move. These applications to remove a child permanently from England and Wales are the most challenging and gruelling of family law in England. 10 years ago there were far more successful applications to move permanently abroad, but things are shifting and there has been a change in emphasis whereby the rights of the left behind parent are becoming increasingly important, as are the relationship between the left behind parent and the children that are being taken away. The key to success in either planning to move abroad or stopping a move abroad is careful planning. Osbornes Family Department have had 40 years experience in dealing with this very difficult area of law. We've been involved in some of the key cases in the Court of Appeal determining the future direction that the Court of Appeal may take. If you'd like to have a confidential conversation with myself or any of my colleagues, please don't hesitate to give us a ring. 0207 485 8811. Thanks for watching.